Hello and welcome back. In this segment, we'll be discussing Family and Medical Leave Act, the interaction between the FMLA and ADA, and workers' compensation and military leave. Let's talk about the purpose for the FMLA that Congress prescribes. When Congress enacted the FMLA, it made the following findings. And I wanted to introduce you to these points because I believe they're important in establishing the backdrop for the FMLA and all of the considerations that went into its passage. Congress considered the number of single-parent households and two working parent households wherein the single parent or both parents worked increased hours significantly. It was important for the development of children and the family unit that parents be able to participate in child rearing and the care of family members with serious health conditions. Congress considered a lack of employment policies that could cause a working parent to choose between parenting and job security. Also, inadequate job security for employees with serious health conditions who are unable to work for temporary periods of time. The primary purpose for the Family Medical Leave Act was for family caretaking, most often is recognized to fall on women, and it affects their working lives more than men. Congress made that finding. Congress also found that employment standards that apply to one gender have the serious potential for encouraging employers to discriminate against employees and applicants for employment who are of that gender. The purpose of the Act is to balance the demands of the workplace with family needs to promote the economic stability and security of families, and to promote the national interest in preserving the family in a manner that minimizes the potential for gender discrimination and promotes equal employment opportunities. So when we examine the Family Medical Leave Act, it really is aiming toward avoiding gender discrimination and promoting equal employment opportunities. And that's part of the rationale and the specific findings that Congress made in its passage. Let's talk about the leave entitlement. The FMLA entitles eligible employees of covered employers to take unpaid job protected leave for specific family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. Eligible employees are entitled to 12 work weeks of leave in a 12-month period, 26 work weeks of leave during a single 12-month period to care for a covered service member with a serious injury or illness if the eligible employee is the service member's spouse, son, daughter, parent, or next of kin. And that's under the provision of medical caregiver leave. So the FMLA provides a total of up to 12 work weeks of leave during any 12-month period for one or more of the following: the birth and subsequent care of a child of the employee, because of the placement of a child with the employee for adoption or foster care, to care for a spouse or son, daughter, or parent of the employee if such spouse, son, or daughter, or parent has a serious health condition, and a serious health condition that makes the employee unable to perform the functions of his position. Also for a spouse, son, daughter, or parent due to a qualifying situation when a service member is called to duty or is notified of an impending call or order to active duty in the armed forces for a contingency operation. The law prohibits an employer from interfering with an employee's rights under the law. That's the anti-retaliation prohibitions. And we've already talked about in this course previously the retaliation laws that apply. Anti-retaliation prohibitions certainly are well grounded in the FMLA. The FMLA also prohibits interference with legal proceedings or inquiries into an employee's rights. Let's talk about the measurement of 12 weeks. An employer may choose among multiple methods for calculating the 12 weeks of leave. The options are the calendar year, any fixed 12-month period, that is fiscal year, anniversary year, one required by state law, 12 months forward from the date of the employee's FMLA leave, or also a rolling 12-month period measured backward from the date an employee used the FMLA. Now note the caveat. Whatever method is selected, it must be consistently and uniformly applied by all employees. Let's also talk about the definition of son or daughter. A son or daughter includes biological, adopted, foster, or stepchildren, a legal ward, or a child of a person standing in loco parentis who is 1. Under age 18, 2. 18 years of age or older and incapable of self-care because of a mental or physical disability, and 3. An employer may require the employee to submit reasonable documentation to prove the foregoing or ask for a statement of family relationship. Let's talk about the definition of a parent. A parent is defined as a biological parent of an employee or an individual who stood in loco parentis in place of a parent who has the day-to-day responsibilities and financial responsibilities to an employee where the employee was a son or daughter. This term does not include parents-in-law. Serious health condition. That is a big focus of the FMLA. A serious health condition means that illness, injury, impairment, or physical or mental condition that involves inpatient care, for example, overnight stay in a hospital, hospice, or residential medical care facility, or continuing treatment by a healthcare provider. Now note again a caveat. A chronic health condition requires at least 2 visits per year for the treatment by a healthcare provider or by a nurse or physician's assistant under the direct supervision of a healthcare provider and continues over an extended period of time. The condition may cause episodic rather than continuing periods of incapacity. A period of incapacity, for example, such as inability to work, attend school, or perform other regular daily activities due to the serious health condition, treatment, therefore, or recovery therefrom of more than 3 consecutive calendar days, and any subsequent treatment or period of incapacity relating to the same condition that also involves treatment 2 or more times by a healthcare provider, nurse or physician's assistant, or treatment by a healthcare provider on at least one occasion, which results in a regimen of continuing treatment under the supervision of the healthcare provider. Continuing treatment by a healthcare provider also includes any period of incapacity due to pregnancy or prenatal care, or any period of incapacity or treatment for such incapacity due to a chronic serious health condition. Continuing treatment includes a course of prescription medication, therapy or therapy involving special equipment. Continuing treatment does not include the taking of over-the-counter medicines, bed rest, fluids, exercise, etc. that can be initiated without a healthcare provider. Conditions which generally are not serious health conditions. Treatment by a healthcare provider for substance abuse may be a serious health condition. However, absence due to the use of a substance is not a serious health condition. Let's look at eligibility request for the employee. In order to be eligible for an FMLA leave, an employee must work at a location with 50 or more employees within 75 miles of that location, work for the employer for at least 12 months, and work at least 1,250 hours in the preceding 12-month period. So these would be for eligibility request of whether the FMLA is available. These are the criteria that must be met. I want to go back for just a moment on the employee eligibility request. Please note the distinction between 50 or more employee requirements for the employers and the 50 or more employees within 75-mile radius for the employee requirement. It is possible for the employer to be required to comply with the FMLA, yet the employee not be eligible for the FMLA benefits. Again, because of the 75-mile radius issue. One other note that I think is interesting, and that would be when an employee is not required to track their time worked, it's incumbent upon the employer to prove that they have not worked 1,250 hours. Okay, let's look at employers required to comply with the FMLA in a little bit more detail. Generally, an employer means any person engaged in commerce or an industry which affects commerce and employs 50 or more employees for each working day during each of 20 or more calendar weeks in the current or preceding calendar year. The weeks do not need to be consecutive, however. This includes any person or acts directly or indirectly in the interest of an employer, to any of the employees of such employer, any successor in interest of any employee, I should say any employer, and public agencies. Intermittent leave. Intermittent leave is also available under the Family Medical Leave Act. An employee can take leave on an intermittent basis if the leave is taken as a result of the employee's own or an eligible family member's serious health condition. Employees taking intermittent leave must make a reasonable effort to schedule the leave so as not to disrupt the employer's business operations. If the need for leave is foreseeable, the employer must provide, I should say the employee must provide 30 days notice. The employer may temporarily assign an employee to another position with comparable pay and benefits that better accommodates the intermittent leave or reduced schedule. However, the reassignment may not be an attempt to discourage the employee from taking the leave. That would be a day, for example, a day shift worker is reassigned to the night shift, and a white-collar working employee is reassigned to a labor position. That would be an example that would be impermissible. When the employee no longer needs the intermittent leave, he or she must be transferred back, however, to the same or similar position. Intermittent leave may not be taken for the birth, placement, adoption, or fostering of a child. Let's talk about calculating time used for intermittent leave. And this is important. Only the amount of leave actually taken can be counted toward the 12 weeks of leave. If the employee normally works part-time or variable hours, a pro rata basis from the new schedule to the old must be used. Let me give you for example. If the employee normally works 30 hours per week and is now working 20 hours per week, the employee's 10 hours of leave would constitute 1/3 of a week. If the employer has made a permanent or long-term change to the employee's schedule, the hours worked under the new schedule are to be used for making the calculation. If the employee's schedule varies each week, a weekly average of the hours worked should be used. Employers are required to use 12-month average of hours worked before the leave to determine what would be a normal work week. An employer cannot charge the employee with more time than that actually taken. Therefore, the employer must use the smallest increment of time the employer uses for other forms of leave, but in no event can the amount of time exceed 1 hour. These are just some technical aspects of how calculating time is used. It's of note that intermittent leave can be applied when an employee is unable to work overtime hours. That would be, for example, the additional hours the employee is unable to work can be deemed FMLA. Let's look at employee notice requirements in a little more detail. The employee must give 30 days notice of the need to take a leave of absence if the leave is foreseeable. In other words, if the leave is anticipated, there's enough knowledge that it's going to be needed, then 30 days is required under the Act to be provided the employer. Let's talk about medical certifications. An employer may require an employee to provide a medical certification from his or her own healthcare provider or that of the employee's ill family member. The employer shall give written notice each time the certification is required. An oral request for subsequent certifications is also sufficient. At the time the notice is given, the employer must also advise the employee of the consequences for failure to do so. Again, look at a caveat. The employer can only request a certification for leaves on an intermittent reduced schedule once every 30 days if there are reasonable safety concerns. Let's talk about the possibility that spouses may be employed by the same employer. If two spouses work for the same employer and both are eligible for FMLA leave, they are limited to a combined total of 12 weeks of FMLA leave for qualifying reasons other than their own serious health conditions. Under these circumstances, each employee is still entitled to a total of 12 weeks of leave. Now, let me give you for example. If a husband takes 7 weeks of leave to care for his newborn child, he still has 5 weeks of leave remaining to care for his own serious health condition. Compensation during FMLA leave. FMLA leave is generally unpaid. However, an employer may choose or an employer may require the employee to substitute other accrued forms of paid leave. For example, The employer can require that vacation time or sick time be applied against that leave period. An employer is not required to substitute the paid leave in any situation in which the employee's uniform policy would not ordinarily allow for paid leave. I think it should be the employer's uniform policy would not ordinarily allow for paid leave, not the employee's uniform policy. Interesting issue here involves health care coverage during the leave. An employer is required to maintain any pre-existing health care coverage during the leave period as long as the employee continues to make any whole or partial premium payments he or she was paying prior to the leave. When the employee returns from leave, the employer must reinstate coverage on the same terms as before the leave started. I want to give you a couple of thoughts to consider. If the employee fails, for example, to return to work at the end of the 12-week leave period, due to a reason other than the serious health condition of the employee, or the employee's immediate family member, or another reason beyond the employee's control, the employer may recover the portion of the employee's premium it paid to maintain coverage during the employee's leave. So, an employer may cease coverage if an employee's premium is more than 30 days late. In addition, the employer must provide written notice to the employee that the coverage will cease on a specified date, not less than 15 days from the date of the letter. If coverage lapses due to non-payment, the employer still has an obligation to restore the employee to coverage or benefits equivalent to those that the employee would have had if the leave had not been taken. The employee cannot be required to meet qualification requirements imposed by the plan, including waiting periods, medical exams, or etc. The employer who pays the employee's insurance premium during the leave may also recover those payments from the employee if the employee does not return. And an employer may also recover premiums paid on behalf of the employee if they fail to return following the leave, unless there is some type of reoccurrence or continuation of the serious health condition or other circumstances beyond the employee's control. Let's talk about rights of the employee upon return to work. An employee has the right to return to the same position or an equivalent position with equivalent pay, benefits, and working conditions as those at the initiation of the leave period. The taking of the FMLA leave cannot result in the loss of any benefit accrued prior to the start of the leave. Equivalent terms and conditions include the same shift, same approximate work sites, same opportunities for bonus, profit sharing, etc. That's really a bedrock principle of the FMLA leave, is that they have a right to return to the same position or an equivalent position with the equivalent compensation, benefits, and status. The right to reinstatement is no different than if the employee had remained working. For example, if the employee had been hired for a specific term and the term has concluded, or if the department was eliminated, the employee does not have to be rehired. So let's think about that for a moment. If an employer reduces its workforce, eliminates positions while the individual employee is on leave, that individual is not guaranteed a position that otherwise no longer exists upon their return or conclusion from the FMLA leave period. Let's talk next about key employees. A key employee is a salaried FMLA eligible employee who is among the highest paid 10% of all employees employed within a 75-mile radius of the employee's worksite. Earnings include premium pay, incentive pay, and bonus. It also includes incentives where the value is determined in the future. It does not include incentives where the value is determined in the future. For example, stock options. There's a typo in my slide. An employer must give notice of key employee status, however. We've already talked to some extent about the employee's notice of intent to return to work. The employer may require an employee to periodically report on the employee's status and intent to return to work. If the employee unequivocally gives notice of his or her intent not to return, the employer's obligations under the FMLA to maintain health benefits and to restore the employment status ends. Let's talk about what happens when the FMLA is violated. What are the rights of an employee? What are the potential risks of the employer for violations? The employee may file a complaint with the Secretary of Labor through the U.S. Department of Labor. The Department of Labor may actually file a lawsuit, a civil suit, on behalf of that employee. Private lawsuits are also available. Now, please note that there's a 2-year statute of limitations from the date of the violation. No 300-day period is required for the FMLA. There's not a requirement to go to the EEOC. There's no 180 or 300-day period of limitations. Instead, the limitation period is 2 years from the date of the violation. If the violation was willful, the filing period is extended to 3 years. Now, what are the available damages? Or what are some of the available remedial reliefs? One would be damages. Damages, however, would not be compensatory in nature, but economic. Wages, for example, employment benefits, compensation lost or denied as a result of the violation. Where no tangible loss has occurred, such as the denial of leave, actual monetary loss sustained by the employee as a result of the violation can actually also be recovered. Interest can be recovered, an amount equal to the sum of the foregoing, if the violation was willful, is always going to be available. Equitable relief includes, for instance, reinstatement, instatement to employment after a period that is ended, promotion, etc. Attorney's fees are available, expert witness fees are available, and cost. Let's turn to a topic that often arises within the context of an FMLA leave if there has also been an injury that's occurred in the workplace to the employee. So with regard to medical certifications, if FMLA and workers' compensation leave are taken concurrently, and they may be in some instances, and the Workers' Compensation Act permits the employer or its representative to request additional information beyond that allowed in the FMLA from the employee's healthcare provider, the FMLA does not interfere with that right, and the information may be used to determine the employee's right to continued FMLA, or even the existing application for FMLA. Workers' compensation leave time does not count in calculating whether the employee worked 1,250 hours. If an employee is able to return to a light-duty position as opposed to the original or an equivalent position, the employee can decline the position, but the employee may lose workers' compensation benefits under state law. If the employee is receiving workers' compensation benefits, the employer cannot force substitution of vacation, sick, or other paid leave. Let's talk about the possibility, and it often exists, that there may be an FMLA issue along with an Americans with Disabilities Act issue. There are many situations in the Americans with Disabilities Act and the Family Medical Leave Act where they may apply simultaneously. If the basis for the leave may also be a disability under the ADA, the FMLA does not prevent the employer from requesting medical information under the ADA, and the information may be used to determine the employee's right to receive FMLA leave. FMLA requires the employee to be returned to an equivalent job. The ADA also allows the return to the same job. Leave under the ADA may be longer than a 12-week period of time. That's important to note. The FMLA may expire at the conclusion of the 12 weeks, but there may be a reasonable accommodation necessary to allow the employee a longer or an extended period of time in order to return to work so as to perform the essential functions of the job. The requested medical information should be limited also to the ability to perform the essential functions of the job. When both the FMLA and the ADA are applicable to the same situation, whatever law provides the greatest benefit to the employee is what must be applied. Let me note that again. When both the FMLA and the ADA are applicable to the same situation, whatever law, whichever law, the ADA or the FMLA provides the greatest benefit to the employee is what must be applied. If an employee has a serious condition that constitutes both a disability under the ADA and a condition under the FMLA, the employer must simultaneously offer the employee the applicable rights pursuant to both. The ADA provides that an employer only needs to maintain health insurance for an individual leave on part-time status if it does for other employees on various leaves or also on part-time status. The FMLA requires that insurance be maintained at the existing level of coverage, including family or dependent coverage under the group health insurance for the duration of the leave. Finally, let's talk about military leaves and reemployment rights. The Uniformed Services Employment and Reemployment Rights Act, USERRA, was enacted in 1994 to encourage non-career service in the armed services, minimize the disruption experienced in the civil careers of reservists, and prompt reemployment of individuals upon return from military leave or from military service for their leave rights to occur. I've asked you before throughout this course to always think about what's taking place in our society when these major legislative acts are passed. The FMLA was in 1993. What's taking place in 1993? There was a focus on the family. There was a focus of individuals who are working part-time and full-time jobs, and having individuals who are married working full-time jobs. So Congress was sensitive to that and considered the need for leave and the need for situations where medical care was necessary for such leaves in order to protect their jobs. In 1994, ERISA was enacted, and that follows after the Persian Gulf War back in the early 1990s. So think again in terms of what's taking place in our society when these acts are passed. What's been the initiative? What's been the impetus behind Congress to consider these matters and respond with a legislative enactment? Let's talk about the military leave and reemployment rights under USERRA in more detail. Section 4312 of USERRA generally requires returning reservists to be promptly reemployed and return to the same or comparable positions of like seniority, status, and pay that they would have had they not been activated. The Act provides that persons reemployed under the Act shall not be discharged from employment within 1 year of their reemployment if the period of service was more than 180 days. For service more than 30 days, the protected period is 180. Note the caveat. The employer may terminate an individual for cause regardless of the duration of service. Now, before we leave this select application of USERRA slide, let's stop and think about this for just a moment. Remember, in most of our subject discussions, we've been focusing on at-will employment. This is an exception to the at-will employment rule. In fact, Congress imposes upon the employer reemployment for a period of 1 year following the return to from active service if it was for more than 180 days. The employer cannot fire that individual unless that individual exhibited a cause basis to do so. So what do we have with respect to the at-will employment rule for this application of USERRA? We don't have the at-will employment rule. It's been suspended for 1 year, absent a cause determination. That's a policy statement Congress has made. So think about that in the context of rationale, policy, and the reasons for enactments, and also what's taking place in our society when these acts are passed. Let's look at some other select applications of USERRA. The USERRA provides that an individual who is a member or who has an obligation to perform service in a uniform military service may not be denied initial employment, reemployment, retention in employment, promotion, or any benefit of employment by an employer because of the individual's service obligations. A military person has rights under USERRA if the following conditions are met. The employee gave advance written notice or verbal notice to the employer of the absence, of the anticipated absence. The cumulative absences, including previous absences, of the employee do not exceed 5 years. And, of course, the employee applies for reemployment. Let's look at some of the exceptions to USERRA, and these are general exceptions. Reemployment is not mandated when it poses an undue hardship. Where have we heard that term before? Well, again, the consistency in the law with some of these terms and conditions remains very current, very consistent. There's a thread of consistency that's throughout these areas of law. So reemployment is not mandated when it poses an undue hardship on the employer or if circumstances have changed so as to make reemployment impossible or unreasonable. Employers are not mandated to reemploy veterans who have sustained injuries as a result of their military service, prohibiting the performance of the essential job functions. But accommodations must be reasonable. Where have we heard those terms before? I think you know from our previous study and your course taken so far. Special retraining considerations are required in certain circumstances. So there we have concluded our discussion for this segment involving family medical leave, the interactions between workers' compensation laws, the ADA, and then the Uniformed Services Employment and Reemployment Rights Act. Make sure that you read carefully those sections within Professor Twomey's textbook. And if you have further questions or concerns, always feel free to contact me accordingly. Thank you.